Security and benefits issues, and domestic abuse injunctions, credit harassment, foreclosure, and migrant farm worker issues. And that also includes an eviction defense as well. So while legal action provides this wide range of services in-house at our firm, there's just simply not enough staff attorneys to meet the needs of the community, as you might imagine. And that is where the Volunteer Lawyers Project comes in. So volunteer attorneys provide pro bono representation on a variety of case types, including bankruptcy hearings, unemployment appeals, driver's license recovery, expungements, domestic abuse injunctions, and civil legal aid.
Oh, no, you're not.
Yeah, Gravity comes up right now.
One of the largest undertakings of the Volunteer Lawyers Project is the Eviction Defense Project that I've talked about, or the EDP as I'll refer to it. So the EDP is one of the most impactful ways that legal action is able to provide housing law services. And through the EDP, volunteer attorneys provide brief legal services and advice pro bono for Milwaukee renters facing eviction. And we'll talk about that more in depth about the process and the impact of the EDP. But first, let's briefly look into the eviction crisis that renters are facing right now. So while the eviction and broader housing crisis in this country existed before the pandemic, the economic catastrophe brought on by the pandemic has only made things much worse for renters, kind of highlighting the need for changes that will help them in these issues that they're facing. So when the pandemic started early last year, many states in one way or another protected renters from evictions. From March to July of last year, we kind of had those protections set in place. And then the CDC halted evictions further for non-payment of rent specifically when it presented its federal eviction moratorium. And it was extended a few times, but it ultimately expired when the Supreme Court of the United States ended it just a few weeks ago on August 26th. So the CDC moratorium, it had prevented millions of renters from losing their homes during the pandemic, and it allowed them to try to catch up on their rent using government assistance that's been provided as well. But all the while, landlords were still threatening eviction and pressuring tenants into paying past due rent and late fees. So now more than ever, it's very important for tenants and landlords to take advantage of rent assistance from states, cities, the federal government, all of the places that this money is coming into play to help renters. And providing counsel for renters to help navigate the administrative hurdles that inevitably go hand in hand with applying for these government programs, the complex legal system. Providing counsel for that can be instrumental for the necessary task of dispersing this money and helping renters in need. So looking at evictions in the context of the pandemic that we've just talked about really highlights the need for systemic change, particularly through providing counsel for renters facing eviction. So let's take a look at evictions nationwide here. So this graph that you see from the Eviction Lab, it demonstrates weekly eviction filings nationwide relative to the historical average. So the vertical red dash shows when the COVID-19 pandemic started. And you can see that right after the pandemic started, eviction filings decreased relative to prior years. And the red bars that you see are the brief time when there was no federal eviction moratorium. So as you can see, at this time, eviction filings, they increased again and then decreased once the federal government put the plan back in place. So the glimpse at the eviction filings, both before the pandemic, before the dotted red line, and then when there was no federal plan in place, kind of give a glimpse of what we're about to see, and frankly, what we have already seen in the short time since the expiration of the CDC moratorium. And this all once again highlights the ever important need for counsel in eviction cases. So now let's look at evictions here in Wisconsin. So as you can see, both eviction filings and judgments were both higher in 2019 than they are now in 2021. And this is in large part due to the moratorium put in place to halt evictions. But what's even more striking is that regardless of the year, the evictions filed are more than the actual judgments given by the court. So that means that while there are evictions that are filed, if the court hasn't made a decision that actually grants the eviction, grants the writ, presents all of that, then that's a good sign to see that the actual judgments are less than the actual filings. And this is in large part because of representation in court by an attorney, because attorneys are able to help the tenants through the complex legal process and raise legal defenses that they might not have known existed. So this shows that representation in court can be very, very instrumental for helping renters. So now let's look at evictions in Milwaukee, both the city and Milwaukee County as a whole, just sort of as an illustration. So you can see that the rates have gone down in 2020, but the numbers are still striking. And in a population of about 600,000 people, anywhere from 10 to 14,000 renters are evicted each year. And with these numbers, it's really important to consider that renters make up more than half of households in Milwaukee County. And systemic change is necessary in Milwaukee, particularly because of the stark segregation in Milwaukee and the disparate impact that these systems have on underserved communities. And that's especially present in Milwaukee. So now let's talk a little bit about evictions themselves. So why do evictions happen? So they happen for a number of economic and interpersonal reasons that you see here, and such as the COVID-19 pandemic, poor communication, bad relationships between tenants and landlords, and conditions issues, housing conditions issues, and etc. So, but the main reason for evictions is poverty. But what's more, eviction, it's not just an effect of poverty, it's a cause of poverty as well. So I'm seeing a question in the chat. Would evictions that simply aren't followed through be included there? We worked with a lot of folks where evictions are filed, but then the landlord doesn't go to court because the tenant moves out prior to the court date. So those numbers would just be evictions actually filed with the court. So if the landlord doesn't go to court, but it was actually filed and it was dismissed, then it would count in those numbers. But if they just presented a termination notice kind of threatening the eviction and the tenant moves out before that, then it wouldn't be included. So I hope that provides some context, and we'll talk more about that a little bit later. So evictions can have a number of personal and practical impacts on renters. But first, let's look at the personal impacts of eviction. The most obvious of those would certainly be displacement and homelessness. Eviction causes individuals and families to lose their homes and be expelled from their communities. And when this happens, folks have to move. And it's often very difficult to move and find new housing, particularly when the reason one was evicted was because of financial reasons in the first place. Eviction can also cause job loss. The stress of finding new housing and the residual effects of the stress can affect one's job performance in a negative way, resulting in negative employment consequences. And further, if one has to find new housing, new employment in a new location, it's difficult to find a job without a permanent address. And employment is heavily reliant on location and transportation, and housing instability affects both of those things. Eviction also impacts one's health, as you can imagine, both physical and mental. Obviously, when folks aren't able to, stay home, when they're not able to stay home, then it's difficult to stop the spread of COVID and other communicable diseases. Eviction is also related to food insecurity and thus hunger. And when folks are in deep need of housing, they may be more inclined to move into housing with poor conditions, such as mold, bed bugs, etc. And as we'll talk about, renters are less likely to disclose these poor housing conditions for fear that they might be retaliated against because of their complaints. So then in terms of mental health as well, eviction, obviously, it causes stress. The displacement, employment concerns, and physical health concerns place a large emotional burden on renters facing eviction. And further, the perception of the systemic unfairness that goes along with eviction, it further exacerbates this the eviction related stress and the mental health concerns that go along with that. So education is also impacted by eviction. There are obvious safety concerns that go along with unstable housing and potential homelessness. Family units are impacted by eviction, as families can be separated by the displacement and relocation. And folks are also at risk of losing their possessions when it comes to eviction as well. So overall, the most important thing to remember and the most striking impact of eviction is that it's not just a condition of poverty, but a cause of it as well. So then, while there are these personal impacts of eviction, there's also practical impacts of eviction as well. So evictions, they're part of the public record. They show up on a renter's CCAP record, which is basically the court system's public record. And because of this, landlords are able to be particular based on what they can find about a person's rental history. They can look on CCAP to see if a renter has been evicted before, or even if there was just an eviction filing against them, and then choose to rent to them based on that. And this is why it's so important to either hopefully avoid evictions in the first place with negotiations, pre-trial, stipulations, things like that. All of this before it even enters the court system. But if that's not possible, it's really crucial to try to seal or redact the renter's name from the CCAP record as well, after the court hopefully dismisses the case in its entirety. So that way the eviction won't be a part of the public record, and renters will not have to suffer the effects on their long-term housing options. And we'll talk a little bit more about those things that I've just discussed with the seal and redacting names from the record as well. So as you might imagine, eviction has a disparate impact on renters. While evidence shows that eviction affects renters in both rural and urban areas alike, eviction filings increase dramatically in areas more densely populated by people of color. And although Black and Latinx communities have long been disproportionately affected by eviction and the adverse health outcomes associated with it, the COVID-19 pandemic has exacerbated racial disparities in both eviction and health. And even though at least 1.55 million fewer eviction cases were filed nationwide in 2020 than would be filed in a typical year due to moratorium, things like that, the demographic characteristics of those facing eviction, it has not changed. Black and Latinx renters, particularly female renters, are disproportionately at risk of being filed against for eviction and being evicted. And this disparity highlights the need for systemic change at an even higher level. So we'll take a look at that. But first, I see there's something in the chat, so I'll address that quickly. A lot of landlords serve eviction notices without filing them with any authority. And this can be to the benefit of renter because it often doesn't always get officially filed and go against them for future rentals. If they move out under the requested terms, some landlords just don't file. I like to think that they are not filing out of compassion for the future rental ability of tenants and because they don't want to incur the legal fees of fully filing. That's certainly true, and that's actually not something that's, as you can imagine, that's allowed under the law. That's called a self-help eviction, and we'll talk about that a little bit more. And that's certainly something to be aware of, because in order for these evictions to be valid, they have to follow a strict legal procedure. Otherwise, tenants can have other ways of legal recourse as well. Okay. So we talked about how there's sort of this systemic unfairness in eviction court. So that's kind of shown here. Slightly more than 50% of landlords were represented by an attorney in 2016, whereas less than 1% of renters were represented by an attorney. And this creates a massive gap in justice. So having representation in court, as you can imagine, in any type of court proceeding can drastically affect the outcome of that proceeding. And when the proceeding is as important as an eviction proceeding, such that a renter maintains housing stability and does not have to endure those personal and practical impacts of eviction that we just discussed, it's really crucial that renters have representation to help them navigate the legal system and advocate for themselves. So eviction proceedings historically have been skewed towards landlord interests. And even despite that, even so, tenants default at high rates without legal assistance, mostly because they just don't show up to their court proceedings, and then there's a default judgment against them. So in many ways, tenants are systematically set up to fail in eviction proceedings. And as we'll see, providing counsel to tenants in their eviction proceedings, it directly counteracts this unbalanced system and seeks to close the justice gap. So let's talk a little bit more about counsel in eviction cases, and more specifically, the right to counsel measures that many cities, including Milwaukee, have begun to undertake. So right to counsel measures ensure that tenants who are facing the complex process of an eviction proceeding are guaranteed legal representation and given a fair chance to access legal protections and stay in their homes. So additionally, tenant attorneys, they don't just help with the legal proceedings, they can also help tenants apply for rental assistance and ensure that the courts do not proceed while such applications are pending, and address situations where landlords refuse to accept rental assistance. So in Milwaukee County, at least when a landlord and tenant agree to either accept rental assistance, the landlord has to sign an agreement that would automatically have the case dismissed. So tenants attorneys can help make sure that these agreements are followed through. So securing tenants' right to counsel, it's one way that federal, state, local governments, they could take action to stop this impending mass wave of evictions and keep people in their home that we have seen and that we're about to see. So here in Milwaukee County, at least, we have two tremendous programs that are designed to provide counsel for low-income renters so that tenants get this fair chance in the complex, unbalanced system. And those are the Milwaukee County's Right to Counsel pilot program and also Legal Action of Wisconsin's Eviction Defense Project. So first, let's talk about the Right to Counsel pilot program in Milwaukee. And I do want to preface that this program has just begun. It's still in its beginning phases. But Right to Counsel Milwaukee was a bill authored by County Board Supervisor Ryan Clancy. And it serves as a way that Milwaukee County can keep residents in their homes and reduce evictions. Milwaukee County Executive David Crowley signed Right to Counsel Milwaukee into law and established a pilot program to provide no-cost legal representation to residents facing eviction or foreclosure. So the program, as I said, it's still in its beginning phase, and it launched just last week on September 1st. It's a partnership between the United Way of Greater Milwaukee and Waukesha counties and the Legal Aid Society of Milwaukee. So county residents making less than 20% of the federal poverty level are eligible to qualify for the free services. So all the while, Legal Action of Wisconsin's Eviction Defense Project, it provides legal representation to low-income renters in Milwaukee County as well. And it continues to do so in addition and in accordance with the Right to Counsel pilot program. So the Eviction Defense Project is a pro bono program where volunteer attorneys provide free brief legal service and advice for Milwaukee County renters facing eviction. So EDP attorneys are able and available to provide representation at the moment a renter really needs help the most, and that's in court, as we've discussed. So the EDP launched in January of 2017, and since then we have worked with hundreds of volunteer attorneys and served thousands of clients. The project is funded by a federal grant from the Legal Services Corporation, and we have also worked and developed partnerships with numerous community organizations, including community advocates, the Milwaukee Justice Center, Legal Aid Society of Milwaukee, Von Briesen, Quarles and Brady, Milwaukee County, the Marquette Volunteer Lawyers Clinic, and more. The EDP also has a Madison location as well that I should note, and it's located in the Dane County Courthouse. So the basics of the Eviction Defense Project are as follows. Services are free to those who seek them. Representation is limited in scope to the time before the hearing until after the hearing ends. But it's important not to devalue limited scope representation. It's still very real representation. It's just limited to a certain time and a certain issue. The program is volunteer-based, so attorneys from firms and other organizations, they volunteer pro bono to provide these services. And then also we're operating completely virtually at the moment. And we'll discuss the virtual process in a bit here so we know how it works. So who is eligible for the Eviction Defense Project services? In order to be eligible for our services, one must be a tenant facing an eviction action in Milwaukee County, and they must pass an income eligibility and conflict screen. So just as with the pilot program, Milwaukee County residents making less than 20% of the federal poverty level are eligible for the free services. So when renters seek our services, they'll call our intake line or our direct lines or contact us in any way. And that's when we'll ask some questions regarding eligibility and general case background. We also require renters to fill out some basic forms such as a retainer agreement before we can provide services as well. So the type of services that EDP attorneys provide, they basically boil down to two things, and that's in-court representation and advice consultations. So in-court representation includes that limited scope representation that we discussed, and that's for clients on their return dates, their first appearances, their trials, motion hearings, all of that. So the volunteer attorney will give advice, help with filling out documents, negotiating, applying for rental assistance and energy assistance, emergency assistance, all of that. And then of course, they'll help with representing in court. So advice consultations, on the other hand, those occur before the actual court date. So if we don't have capacity on the day of the hearing, or if this is pre-filing, like we kind of discussed in the chat earlier, so say the landlord hasn't actually filed the case, but they've given a notice, or they've just kind of indicated that there's an eviction looming, things like that, then someone could call the EDP and they could get an advice consultation with one of our volunteer attorneys as well. And they could help prevent against those self-help evictions that we've discussed as well, because as I said, there's a very strict process that someone must follow through in order to have a valid eviction. So the volunteer attorneys, they can also help with pre-hearing negotiations with the landlord. They can help with applying for rent assistance, things like that. But the important thing to note is that the volunteer attorney, they will not be at the hearing. It's just for before the hearing, and they won't be able to answer any sort of questions after that unless an additional agreement is made between the client and the volunteer attorney. So the virtual process kind of goes like this. So renters seeking our services, seeking representation, they must call the EDP at the number listed in advance and as soon as possible in order to schedule so that we can match them with a volunteer attorney preset to provide representation on that day. So we operate and provide representation on Mondays, Wednesdays, Thursdays, and Fridays. So it's important to note our availability should you have any referrals for us. Tuesdays are days that we are not operating, but any of those other days are days that we have volunteer attorneys available. So volunteer attorneys will then contact the client before the hearing, and then both parties will attend the hearing via Zoom. So the court is still using Zoom for these virtual hearings, and at least in Milwaukee County for the foreseeable future. So the volunteer attorney will then follow up after the hearing via phone or email to debrief, and then they'll discuss sort of the outcomes that occurred at the hearing. And we'll discuss some of the possible outcomes at eviction court for our understanding in just a bit here. So let's now talk a bit about the eviction process in Wisconsin. This will give us a better idea of how counsel plays into this system and can provide necessary assistance for renters facing eviction. So Wisconsin landlord-tenant law is governed by Chapter 704, the housing statutes, the ATCP 134, the housing regulations, Chapter 799, the small claims procedure, and then the general principles of contract law as well. So, as I've said, a valid legal eviction has to abide by the specific laws and procedures laid out in the Wisconsin statutes. A landlord cannot legally self-evict a tenant, despite the fact that, as we've seen in the chat, they often try to do that. So the eviction process is set out in Chapter 704 and 799. And again, it must be strictly adhered to in order for an eviction to be valid and legal. And often the defaults in failing to abide by this process are defenses that counsel can identify and help raise to prevent or delay the eviction. So before an eviction action can actually be filed, the landlord must serve a valid notice to the tenant. Once the notice then expires and the client did not vacate or cure the breach, fix what's going on, and this depends on the type of tenancy and the notice. After that, the landlord can then file the case, file the summons and complaint, and they must serve that upon the tenant. And that's when most tenants come to the EDP after they receive the summons and complaint. So then the tenant must attend their return date. And the return date is the hearing held in front of the small claims commissioner. It's the initial appearance for it. So at that hearing, the commissioner can dismiss the case, adjourn the case, grant the writ, or set the case for trial in front of a small claims court judge for a contested hearing. And it all depends on the circumstances of the case. So if there's a trial, then after the trial, there can be post-judgment motions, appeals, and then eventually hearings on the second and third causes of action, which are for rent and damages. So the EDP typically only represents for the first cause of action. The first cause of action is the eviction itself, so the actual removal of the tenant from the property. So as I was saying, the Milwaukee County Courthouse is still handling all proceedings remotely using Zoom for the foreseeable future. So clients must be prepared to take part in these proceedings virtually, and they can do that using the phone as well. It's not just Zoom that they need to have access to, but it's still, it raises questions about accessibility for court. But any documents that the court will need to see need to be gathered and filed in advance. All right. So let's look at some of those things that we just discussed. So the termination notice. A termination notice, it must be written and given for the correct reason and type of tenancy. So that means that if a client or if a tenant has a tenancy under a lease, so they have a year-long lease, they can only receive a certain type of notice for an eviction to be valid. Whereas if a tenant is under a periodic tenancy, such as they just stay there month to month, there's no real agreement, then there are other types of notices that can and need to be given for that. So reasons for a termination notice include no reason at all, non-payment of rent, behavioral reasons, breaches of the lease, criminal activity, and nuisance. So for periodic tenancies, like I just said, so typically month to month, and then tenancies at will, which are just tenancies where someone's staying with someone, they don't pay rent, there's no agreement. For those things, the notice must give the tenant 28 days to vacate from the date it is given. So that's not the case for tenancies involving a lease for a year or more. There must be a reason. And the most often, the reason that we see for those are non-payment of rent, especially right now. So under tenancies for a lease, the tenant can only be given 5 days to pay the rent or vacate. But if there's a second breach within 12 months, they can be given just 14 days to have to vacate. So it's important to note the circumstances that call for different types of notices. So this obviously doesn't apply for tenancies at will where the tenant is not paying rent. But there are similar circumstances for behavioral breaches and things like that as well. But termination notices for criminal activity and nuisance, they must follow a specific procedure set out in the statutes, and they typically don't require an opportunity for the tenant to be able to fix the alleged breach. So it's important to note that if notices are vague, misleading, contain incorrect timing, or if they fail to provide an opportunity to pay or cure when required by statute, those can all be considered invalid and lead to dismissal of the case. And oftentimes tenants, they're not aware of their protections under the law. So counsel are able to identify the defaults and the invalid termination notices and raise those at trial for tenant protection. So once the termination notice expires, the landlord or their agent, they can file the eviction case with the court. So the landlord must file the summons and complaint with the court, and they must set out a statement of facts identifying the basis for the eviction action and their damages sought. So the summons and complaint, it also sets the initial court date for the eviction action that the tenant really must attend. So then the summons and complaint, it must be personally served upon the tenant. And only after reasonable and failed attempts can a landlord use a form of substituted service, such as leaving the summons and complaint with the language is a competent family member above the age of 14. And then if that method is not available, then summons and complaint can be mailed to the tenant's address and then posted in a conspicuous area. And again, like I said, that can only take place after reasonable and failed attempts to actually personally serve. And again, that's something that maybe the tenant is not aware of, but if they bring this issue to their counsel, they can identify this procedural default, and that can help lead to delay or dismissal of the case. So now let's talk a bit about the outcomes at eviction court. So the first is that the case can be dismissed. Obviously, this is the ideal option. And this can be by a court order or a stipulation, which is an agreement between the landlord and the renter that requires further compliance to kind of maintain the dismissal, such as a payment plan or a timeline for moving out, things like that. But stipulations are still very favorable results for renters, as it gives them adequate time to move out and find other housing, while also still paying back their non-paid rent, hopefully, from government assistance, things like that. And then all the while, the renter will not have this eviction on their record. So the case could also, if it's not dismissed, it could be adjourned or delayed, but it could also be set for trial in front of a judge for a contested hearing on the facts of the case. And this typically occurs when the tenant or their counsel has identified a legal issue that needs to be addressed, and it's set for a trial in front of a judge. So another option, and one that's very important, is for the court to seal the CCAP record, meaning, again, that the mere fact that the renter was even in court for an eviction will be sealed and thus not part of the public record. So this requires a court order from the judge. And thankfully, at this point in time, the court in Milwaukee has been relatively willing to grant motions to seal records, but there are some circumstances that have to go along with that in order for a court to grant that redaction of the name from the record. So then, of course, the court could also grant the eviction, which is called a writ of restitution. So this means that the court will allow the landlord to go through with the eviction by going to the sheriff and arranging a time for the sheriff to remove the renter from the premises. So as we kind of said before, it's important to note that without this writ of restitution, without this actual judgment from the court, a landlord cannot take matters into their own hands and evict a tenant. So let's take a little closer look at these options for outcomes. So first, it's important to note that we want to know for sure, was the case dismissed in its entirety, or was it just the first cause of action? So as I kind of said before, the first cause of action is just the eviction itself. So that part of the case being dismissed, while it's very important, it keeps having an eviction off one's record, it doesn't always stop the landlord from being able to get rent and damages from a tenant. And those are the second and third causes of action. So sometimes the court will dismiss the first cause of action, but set a date for those other causes of action, the rent and damages. And if there's still a hearing date for those, then the case is considered open until those issues are resolved. So if the case is still open, then it'll be a lot more difficult to get the case sealed, even if the eviction action itself was dismissed. So if the case is dismissed in its entirety, or even just once the case is dismissed in its entirety, we've seen it can be sealed and the tenant's name redacted from the record. So this requires an affirmative motion to the court, which the EDP often helps represent clients, or at the very least, helps them draft the motion. So that's another way that counsel is very important in helping renters maintain housing stability and go and counteract those long-term housing options that sometimes and often do come up as a result of eviction actions. So I'm seeing a question here. Oh, sorry, Heidi, did you have something? Okay, so the question in the chat, how often do renters actually win these eviction cases? The law and the judges are almost 100% on the landlord side, even if the landlord has not followed proper procedures. So it's hard to say, because you're absolutely right that, and we've discussed that these cases and the court systems themselves are really skewed towards landlord interests. So ways that the renters can actually win these eviction cases, as you're saying, since the law is often on the side of the landlords, we do see that, you know, in court, perhaps renters actually winning is not something that we often see. However, when it comes to negotiating pre-trial, those stipulation agreements, or coming to an agreement about rent assistance to get the case dismissed, we do see that quite often. And counsel is able to really help with those sorts of things. So while the law may not be on renters' side always, counsel can still help tenants come out on top in other ways as well, through these agreements, through rent assistance, but also at the same time, even, you know, as you've said, even if landlords have not followed proper procedures, maybe the court is more lenient with landlords and allowing them to amend their improper procedures. At the same time, having someone there to actually bring that up is very important, and oftentimes the court will side with the tenant when there are blatant procedural errors as well. So it's definitely noted that court can be on the side of landlords, but providing counsel is a way to counteract that by these options outside of court, and then also by still just being there to identify these issues and make a strong case against them. Okay, so let's talk about if a case is set for trial. So if the case is not dismissed or adjourned at the return date, it could also be set for trial for a contested hearing, as we've said. So the tenant will have a trial date set for the future, and they should be prepared to appear and present evidence related to the defenses. So this often comes up because it's a landlord's burden to prove that a tenant actually didn't pay their rent, or actually did breach this part of the lease. They have to actually prove that in front of a judge. So counsel can help with these evidentiary proceedings. So the EDP, we typically represent tenants at their trials if we've represented them at their return date. So that's where one of the volunteer attorneys, they were at that initial appearance and they found a valid legal defense, and they requested that there be a trial to actually have the landlord prove that. And these are very helpful because any sort of delay in the eviction process is very helpful for tenants to maintain their housing stability. It helps them be able to move before an eviction action is granted against them, and it helps them be able to get rent assistance before any dispositive decision as well. So any sort of delay is good. But like a dismissal at a return date, if the case is dismissed at trial, the case can be sealed once it's dismissed in its entirety. And something that the EDP can do, or that any counsel can do, is that at this contested hearing, in front of the judge after the dismissal of the case in its entirety, they can bring up the motion to seal the record, to redact the name right then and there. And they can have that hearing right there by raising that agreement, that argument orally. And so long as both parties are present, the landlord and the tenant, they could have that right then and there and get the case sealed at that time. So some of the defenses to eviction that are commonly raised at a return date and then set for trial at a contested hearing, and we've kind of talked about it, but just to lay them out here, there are procedural defenses like lack of ownership, meaning that the plaintiff who filed the case and who's named on the court record, they're not actually the owner of the property. And that's something that we see quite often with landlords doing. And counsel, they're able to identify that defense and raise it to delay the eviction, get it dismissed. We also see invalid notice, improper service of the summons and complaint, like we discussed. So those are procedural defenses that can be raised. But there's also substantive defenses that can be raised, such as the tenant actually did pay their rent and or cure their lease violation within their given time in the termination notice, or simply that there was no breach at all. There's also defenses for retaliation on part of the landlord as the basis of the eviction, reasonable accommodations for tenants with disabilities, or rather that the landlord failed to consider them in giving the termination notice. And then there's contract defenses like unconscionable terms, things like that, bankruptcy, which often stays in eviction, and then subsidized housing as well. There are certain procedures that need to be followed for subsidized housing. So as we've discussed, what's really, really important for renters after their case is dismissed is to obtain this CCAP seal. So the CCAP seal, it modifies the online record of the eviction filing to redact the name of the affected tenant. So the case, it's still visible online, but if a landlord, a prospective landlord, were to search the tenant's name, they would not be able to find it. They would not be able to find that case because their name has been redacted from the record. And that's really important because, as we discussed at the beginning of the presentation, landlords, they often use CCAP to see if there have been eviction filings against tenants and choose to rent to them based on that. So having the name redacted and having potential landlords unable to find eviction filings is very important. So in order to get the seal, though, as I said, there are some circumstances that need to apply. So the court will balance the public interest in access to information. So the public interest for prospective landlords to be able to know these things. They weigh that against the private interests of the individual tenant and the negative impact on the tenant's ability to find housing, which is something that is very apparent. So generally, the court will want to see some sort of substantive or procedural flaw in the eviction filing, such that the case never should have been filed to begin with. Or, at other times, the hardship on the tenant to find housing is enough to seal the case. And then even sometimes we see that if the landlord has been made whole, such that they received rent assistance and the tenant is no longer behind on rent, the landlord has received all of their payments, that can be enough for the court to seal the case as well, because of the kind of recognized hardship that tenants face when they're even associated with an eviction filing. So then the last option, there's always the chance that the court will grant the eviction and issue the writ of restitution. So if the court grants the writ, the attorneys, counsel, tenants, they can ask for a stay of a writ for a specific duration or to a specific date to give the tenant time to move out before they're actually removed. But it's at the court's discretion about whether to stay a writ or to put a hold on it for a certain amount of days. And even if they stay the writ, it's still on the tenant's record. So procedurally speaking, after the court grants the eviction, the landlord is given the writ of restitution, and the landlord has 30 days to give it to the sheriff's department. Upon receipt of the landlord's writ of restitution, the sheriff's department has up to 10 days to carry out the eviction then. So in practice, landlords typically they're able to give the writ on the same day to the sheriff they receive it, they go to the court, and they go to the sheriff's department on that day. And then the sheriff's department can execute as quickly as the next day. But during the pandemic, we have seen commissioners and judges that are more willing to stay because of the noted hardship that obviously eviction and moving, things like that, have on tenants. So then, after that, the second and third causes of action for rent and damages are set for a later date. All right, so now that we've talked about some of the outcomes, let's look at the actual impact that the EDP has had on renters in Milwaukee County as sort of an illustration for how council as a whole can really help renters in its entirety. So looking at the impact that the EDP has had on tenants in the past, in 2019, the EDP represented 690 clients, 567 of which in court. So we got 504 out of 567 of those cases dismissed, and then 78 out of 567 of those cases sealed. So as you can see, it can be difficult to get cases sealed because of the weighing the interests and things like that. And oftentimes landlords aren't very agreeable, as you can imagine, to those seals, which makes things a little bit more difficult. But still, we were able to help a good amount of clients get their cases sealed by, moving forward with that motion to redact their name from the record. And then in sum, we've helped save clients over $500,000 based on our representation. So further, council has a broader impact on outcomes at eviction court as well. So when represented, renters avoid eviction 90% of the time. Evictions initially dismissed by settlement are much more likely to be successful because council, they're able to negotiate reasonable terms for a stipulation for a tenant. And then renters are much more successful in getting their cases sealed. So attorneys, they help renters also maintain housing stability by providing resources for rent assistance that help them pay their rent and avoid evictions. So when helping volunteer attorneys prepare for cases, we're always sure to refer renters to rental housing, the Rental Housing Resource Center, which is kind of a one-stop shop for renters and landlords to kind of help with rent assistance, mediation, things like that help with promoting housing stability. So rent assistance is also, it's very important, and it's something that council can help facilitate and things like that for renters to maintain housing stability. So they're also able to refer renters to obtain energy assistance as well. If you can't pay a water bill, electricity, gas bill, they can help facilitate that process as well. And then further, they can help renters apply for emergency assistance as well if renters have children. They're also able to help with that as well. And then attorneys also help renters fight against poor housing conditions like mold, broken pipes, bugs, etc. So as I kind of said before, most renters are hesitant to bring up these conditions because they fear that their landlord will retaliate against them. However, this is strictly prohibited by law, and counsel in cases are able to protect against that. So attorneys can help negotiate with landlords to fix conditions. They can help renters go through the proper legal processes to abate their rent as a result of poor housing conditions, and things like that. So attorneys, they can help make sure that renters know how to legally protect against housing conditions, because oftentimes renters feel that they'll be retaliated against for bringing up these conditions issues. But council's able to write letters to landlords, and there are even some cases where eviction cases are dismissed purely based on habitability defenses alone. So other stabilization methods that council can help raise and advise for renters outside of those defenses that we kind of discussed, those include eviction moratoria, emergency assistance, rent assistance, energy assistance, And then, as we just discussed, rent abatement for housing conditions. So back when the CDC moratorium was in place, EDP attorneys would frequently provide the declaration to the landlord on behalf of the tenant to delay the eviction. This was a major defense to evictions for months that kept tenants in their homes. So attorneys, when they would come to the court to represent the client at the return date, they would inform the court that there was a declaration on file and request an adjournment based on that. So that delay helps tenants be able to obtain rent assistance or come to an agreement with their landlord to avoid eviction. So next we have emergency assistance. So emergency assistance, it's reserved for tenants with minor children facing unstable housing conditions. So if the client meets these circumstances, they might be able to apply for emergency assistance from their local W-2 agency. And if the client applies for emergency assistance, the court must stay the proceeding for a maximum of 10 days under the law. So next, and very importantly, we have rent assistance. So if a tenant has not applied for rent assistance, an attorney will refer them to apply for the rent assistance from, in Milwaukee, we have community advocates, the Social Development Commission, and they'll be able to provide resources that'll help the client walk through the steps of applying for rent assistance through those service providers. And, outside of Milwaukee County renters, there are other providers of rent assistance as well, and those can be located using the Consumer Financial Protection Bureau's rent assistance locator. So as I kind of said before, counsel can help facilitate and guide through the administrative process of applying for and securing rent assistance, which, depending on the agreement, but oftentimes leads to dismissal of many, many cases. So then if the client is unable to make payments for utilities such as power, water, things like that, they can apply for energy assistance through the Home Energy Plus program. So the emergency rental assistance program through service providers like community advocates, the Social Development Commission, they include utility payment help as well. And the council is able to, point out these resources for tenants to be able to maintain this stability in housing. And they can help facilitate the application process as well. So then lastly, council can help look at housing conditions and recommend rent abatement procedures. So it's important to note that, in many places, including Milwaukee, tenants cannot abate rent on their own accord. And then nowhere in Wisconsin can they withhold their rent in full. They must follow the procedures of other agencies that set out those procedures. So often, tenants, they don't want to report these conditions for fear of retaliatory eviction, and counsel, again, can help provide a legal protection for that. But if there are any egregious housing conditions, then counsel can help the client follow the correct rent abatement procedures and provide the necessary legal representation in court as we discussed. And as we discussed, they can negotiate outside of court with the landlord as well. So now let's talk about some of the major takeaways for tenants that help them, kind of navigate the complex legal process and kind of face the eviction process as a whole. So the first and always the most important thing is to always go to court. So more than 50% of cases result in default judgments because tenants don't appear for their return dates. It's important never to withhold all of your rent despite egregious housing conditions issues. So many of these issues, that many evictions, they stem from non-payment of rent due to housing conditions. But tenants cannot abate they cannot withhold 100% of their rent. So then next, of course, it's even weird to just say this, but if possible, always pay on time and in full, because any sort of discrepancy is cause for an eviction. It's important to always keep up with any and all terms of the stipulations, maintain all records such as rent payment receipts, rental agreements, promises between the landlord, get those in writing and have those records. Next, it's important if the case is dismissed, always ask for a seal if possible. Counsel is very able to help with that, but in any case, it's always important to ask for the case to redact the name from the record. Applying for rent assistance is very important. And then last but not least, seek counsel from the Eviction Defense Project or any place that's able to help provide assistance in court, because as we've discussed, the eviction process itself, it's very complicated, it's very skewed, and having any sort of help in that, both in court and outside, can be extremely helpful for tenants. So I know that we're running short on time, but and I've answered some questions as we've gone, but if there's any other questions, I'm happy to go through them right now. And then also I'll just leave this up here. Please feel free to contact me or any of us at the Eviction Defense Project if you have any questions, especially if you have any referrals. We're happy to answer any questions, and especially happy right now to provide representation for renters in need of assistance. So I'll answer any questions, but thank you so much for your attention and for attending this session on how eviction defense and stabilizing housing for low-income tenants can really happen through providing counsel in cases. So I hope I was able to provide some insight for the work that we do, and I hope that you enjoy the rest of the conference. So thank you so much for having me. Heidi, you're muted. So I apologize. We can't hear.
After a year, we should have that down, right? Thanks everybody for attending, and thank you, Abrielle, for that really comprehensive presentation. Hopefully we can all take that information back into our businesses and our organizations and help more tenants avoid eviction.
So
folks?
I'm seeing that there is a question about regarding rent assistance. So recommendations for renters that don't qualify, or sorry, for recommendations for renters that don't qualify for representation, but don't have enough funds to pay for their own representation. So it's kind of a tough question, but there are, you know, while I did say that there are these kind of income eligibility you know, structures that we have, there are also other ways that we can kind of get around those things in certain situations. So, you know, I do recommend always to try to seek counsel, even if you don't think that you will qualify. So that's one recommendation. And then I also know that a lot of organizations, including Legal Action, will often provide know your rights sort of things for folks to come and be aware of the processes and things that they can do on their own. So, you know, any sort of community organization, tenant unions, I know that there are some of those, they provide know your rights things. So just being aware of the processes and defenses is another recommendation.
Other questions from our folks that attended? All right, thank you everybody for attending this session, and we'll see you at the lunch plenary. Have a great afternoon.